In this lecture, we shall discuss consideration. We shall discuss consideration. We shall discuss consideration. Now, the first point to note is that when we were discussing the elements of a valid and a binding contract, we mentioned that there must always be an offer and a corresponding acceptance. We mentioned that there must be an intention to create legal relations. We mentioned that there must be capacity. And we also mentioned that there must be consideration. It means that consideration is one of the elements of a valid and a binding contract. It means that generally, without consideration, you cannot have a valid and a binding contract. So it is important for we lawyers and law students to know what amounts to consideration in law. What amounts to a valid consideration in law. So we shall begin with the definition of consideration. Now, there is a traditional definition of consideration. That's when you read all the textbooks on contract law, you will see this classical definition of consideration. We usually refer to it as the traditional definition of consideration. I say traditional because over time, that definition, which was formulated as far back as in the year 1875, that traditional definition, which was formulated as far back as in the year 1875, we have had modern cases that have redefined and refined the definition of consideration. But in order for you to get a full import of the definition of consideration, I shall begin first with the traditional definition of consideration. The traditional definition of consideration that we shall glean from the case of Currie versus Misa. Currie is spelled Currie versus Misa, Misa. Currie and Misa reported in 1875. Now, what is this traditional definition of consideration that was defined and given in the case of Currie and Misa? Currie is spelled Currie, Currie versus Misa, Misa. Currie and Misa, reported in 1875. Now, this is the definition of consideration that was given in this case of Currie and Misa, and I quote, "A valuable consideration in the sense of the law may consist either in some rights, interests, profits, or benefits accruing to one party. It may consist in some rights, interests, or benefits accruing to one party, or some forbearance, detriment, loss, or responsibility suffered or undertaken by the other." End of quotes. A valuable consideration in the sense of the law may consist either in some rights, interests, profits, or benefits accruing to one party, or some forbearance, detriment, loss, or responsibility suffered or undertaken by the other. Now, what can we get from this definition? From this definition, you get a meaning that consideration would either refer to a benefit you're conferring on another party. For example, you are giving another party money. You are giving another party $1,000. You are giving another party a house. You are giving another party a car. You are giving another party a vehicle, a tractor, whatever it is. But there must be some benefit you are conferring on the other party. So that if you are entering into a contract, before that contract will be valid, the law is saying that one party must be conferring a benefit on the other party. So that if, for example, a contract for me to sell my house to you for me to give my house to you, the law is saying that before that contract can be valid, before that agreement for me to hand over my house to you be valid, there must be some benefit you are conferring on me. So that benefit can be an amount of money you are giving to me, maybe 1,000 Ghana cedis, $100,000, 100,000 pounds. So if I give the house to you, the contract will be valid because you have also conferred a benefit on me in the nature of 100,000 pounds. So that is one of the meanings of consideration that we can glean from Currie and Misa, that there must be some benefits, profits, or rights you are conferring on the other party. It didn't end there. He also said that consideration can also be forbearance, detriment, a party surface. What does it mean? It means that if I sit here and you tell me that I know you are supposed to go to class for the next 1 month, do not go to class for the next 1 month. Undertake this forbearance, or do not eat for the next 1 month. And if you refuse to eat for the next 1 month, if you suffer that detriment of refusing to eat for 1 month, I shall confer on you $1,000. Now, ideally, I have a right to eat, but you have told me not to go and eat. You have told me to undergo this forbearance. You have told me to undergo this detriment. You have told me to undergo this loss of not eating. Now, if I refuse to eat for the next 1 month, that will amount to the forbearance. That shall suffice as valid consideration, for which reason that agreement will be enforceable. In other words, if I refuse to eat for the 1 month, and I now come and sue you for the amount of money, if I refuse to eat for the 1 month and I come and sue you for the amount of money, you can't say that that agreement is not enforceable because I am not giving you anything in return. The law will say that the forbearance I had to undergo in refusing to eat for 1 month, that forbearance will amount to a valid form of consideration. So what you get from Currie and Misa is that I shall read the definition in Currie and Misa once again. And I quote, a valuable consideration in the sense of the law may consist either in some rights, interests, profits, or benefits accruing to the one party, or some forbearance, detriment, loss, or responsibility suffered or undertaken by the other. End of quote. So what we get from the traditional definition of consideration in Currie and Misa, simply put, is that consideration means either a detriment one party is suffering or a benefit one party is getting. It means the detriment suffered by the promisee or the benefit being conferred on the promisor. That is what will amount to consideration if you go according to the case of Currie and Misa. But there have been some other definitions of consideration. For example, if you look at the case of Thomas and Thomas, this is what Patterson J said. Thomas and Thomas is reported in the year 1842, 2 Queen's Bench, at page 851. This is how Patterson J defines consideration. And I quote, consideration means something which is of value in the eye of the law, moving from the plaintiff. It may be some benefit to the plaintiff or some detriment to the defendant. But at all events, it must be moving from the plaintiff. You, the plaintiff who is suing for the house that they are supposed to give to you, for the car that the person is supposed to give to you, you, the plaintiff, must show that you have conferred some benefits onto the promisor, or you, the plaintiff, you have suffered some what? Detriment based on what the promisor told you to suffer. That is why Thomas says that, but all events, it must be moving from the plaintiff. You, the plaintiff that you are suing, show us what consideration you have given to enforce the promise that has been given to you. So that's why in Thomas, Patterson Day defines consideration in the following words: that consideration means something of value, which in the eye of the law, moving from the plaintiff. So consideration means something which is of value in the eye of the law, moving from the plaintiff. It may be some benefit to the plaintiff or some detriment to the defendant. But at all times, in all events, it must be moving from the plaintiff. So what we get from the case of Thomas and Thomas, as well as Currie and Misa, is that consideration always refers to something which is either a benefit or a detriment. Benefit or detriment. That is what we get from the case of Currie and Misa, as well as Thomas and Thomas. Now look at the years in which they were decided. Currie and Misa was in 1875, Thomas and Thomas in 1842. They were around the same time. So around that time, the definition of consideration was along the line of benefit to one party or detriment suffered by the other party. Currie and Misa and Thomas and Thomas. Now the question is, can consideration always be? Must it always be some detriment suffered by one party and the benefit, or consideration can take some other forms apart from a benefit and a detriment? Must consideration always be a benefit and a detriment, or there can be some other forms of consideration? Now, as we move along, you realize that this traditional definition of consideration, along the lines of benefit and detriment, it is waning out into insignificance. This is because there have been some other forms of consideration which do not fall within that traditional approach of detriment and then benefits. So when you look at the case of Dunlop Pneumatic Tire Company versus Selfridge and Company. Dunlop Pneumatic. Dunlop is spelled D-U-N-L-O-P. Pneumatic. Pneumatic is spelled P-N-E-U-M-A-T-I-C. Dunlop Pneumatic. Tire. Tire is spelled T-Y-R-E. Dunlop Pneumatic Tire Company Limited versus Selfridge. Selfridge is spelled S-E-L-F-R-I-D-G-E. Selfridge and Company Limited. Dunlop Pneumatic Tire Company Limited versus Selfridge and Company Limited. Reported in 1915. Appeals cases at page 847. This is how Lord Dunedin is spelled D-U-N-E-D-I-N, or Lord Dunedin. This is how Lord Dunedin defined consideration, and I quote: an act of forbearance of one party. So over here we have an act. We also have forbearance, or we have the promise thereof. So this is how he defines consideration: an act or forbearance of one party, or the promise thereof, is the price for which the promise of the other is bought, and the promise that's given for value is enforceable. End of quotes. What is Lord Dunedin saying? He's saying that consideration can be, first of all, it can be an act. It can also be a forbearance. Or it can also be a promise that another party gives. So, for example, if you tell me that, gentlemen, my car is dirty. If you wash this vehicle for me, I shall pay you 1,000 Ghana cedis. I take the bucket, I go and wash the vehicle. Now you made a promise that you will pay me 1,000 cedis. Now, if I sue you for that 1,000 cedis, the question will be, what is the consideration that I have provided? I will say my act of washing the vehicle is my consideration. And so I can sue you to enforce the 1,000 cedis you promised to me. Let me take it again. You remember the case of Khalil and Kabalik Smokeball Company Limited, where the Kabalik Smokeball Company Limited advertised to the whole world that whoever shall buy the medical preparation, use it according to the instructions, and contract the influenza, we shall pay you £100. The plaintiff bought the medical preparation, used it, and contracted the influenza. Now, his act of performance, that act, was held to amount to an acceptance. Now, that act will amount to the consideration he has provided. So, consideration need not only be a benefit or some forbearance, it can also be an act of performance by one party. So, if you tell me to run from here to Nigeria, that you pay me 1,000 cedis. If I run to Nigeria, my act of running shall amount to the consideration. So in this case of Dunlop Pneumatic Tie Company Limited versus Selfridge and Company Limited, we are being told that consideration can also be an act. So this is more like an addition from what we have seen in Currie and Misa. Because remember, in Currie and Misa, we only saw consideration to be either a benefit conferred on the promisor or the detriment being suffered by the promisee. Right now, we are seeing in the case of Dunlop Pneumatic Tie Company Limited, which is Selfridge and Company Limited, that consideration can be an act. An act one party undertakes. It can also be a forbearance, which I've already explained under the context of Currie and Misa. So I will not spend much time on forbearance. And we have mentioned that consideration can also be a promise. When you say promise, what do we mean? It means that if you tell me that you have gold in America and you bring the gold, you ship the gold from America to Ghana, and also make a promise that, oh, if you ship the gold from America to Ghana to me, I shall pay you $1 million immediately. So relying on my promise, you then ship the gold from America to Ghana. The moment you ship the gold from America to Ghana, you can sue me for that $1 million. Because the consideration I provided was that I made a return promise to you. So in that same vein, if I tell you that, will you ship gold to Ghana to me by end of December? And if you can bring it by the end of December, I shall pay you $1 million immediately. And you say, oh, I promise, I shall ship the gold if you will get it latest by 20th December. Now, because of you, I don't go and deal and buy gold from any other person. I'm waiting for you. If by 20th December you don't bring the gold, I can sue you for breach of contract. And when I sue you, it will not lie in your mouth to say that, but after all, I didn't pay you any money for the gold. I will say that I make a return promise. And in law, the return promise amounts to a valid consideration. So that's why in the case of Dunlop Pneumatic Tie Company Limited versus Selfridge, you will see that we get, for the meaning of consideration, we get that it can be an act. We get that it can also be a forbearance. And we get that it can also be a promise thereof. So I'll read the definition of consideration once again, according to Dunlop Pneumatic Tire Company versus Selfridge and Company Limited, so that we'll get a full import of the definition. And we can see how that differs from the definition we have in Currie and Misa. Remember, this is the case of Dunlop Pneumatic Tire Company Limited versus Selfridge and Company Limited, reported in 1915 appeals cases at page 847. This is how consideration was defined, and I quote: an act of forbearance of one party or promise thereof is the price for which the promise of the other is bought, and the promise that's given for value is enforceable. End of quote. So you've seen the different elements. We have an act, we have a forbearance, or we have the promise thereof. Now, still, a more modern definition, which is widely acceptable, you can look at the case of, you can look at the definition given by Section 75 of the American Restatement of Contracts, second edition. Section 75 of the American Restatement of Contracts, second edition. This is how consideration has been defined in that particular authority. Section 75 of the American Restatement of Contracts, second edition. This is how it defines consideration, and I quote: consideration for a promise is A, an act other than a promise, or B, a forbearance, or C, the creation, modification, or destruction of a legal relation, or D, a written promise bargained for and given in exchange for the promise. So, from Section 75, we have obtained a more advanced definition of consideration, which goes beyond what we have seen in Currie and Misa. It goes beyond what we have seen in Thomas and Thomas. It goes beyond what we have seen in Dunlop Pneumatic Tire Company Limited versus Selfridge and Company Limited. Take a critical look at this definition of consideration given by the American Restatement of Contracts, second edition. Take a critical look at it, Section 75. It says consideration for a promise is A, an act other than a promise. Meaning that once again, we are recognizing that consideration can be an act, like I said earlier, of washing the vehicle. An act, like buying the medical preparation in Carbolic Smokeball Company Limited case and using it. It can be an act when you tell me that paint my house for me, I'll give you $1,000. If I paint, that will be my consideration. So over here, it has been made clearer that the consideration can be an act other than a promise. Or B, a forbearance. Like we saw in Currie and Misa, where you tell someone that don't eat for 1 month, I'll pay you $1,000. If the person refuses to eat, that shall be consideration. So an act other than the promise or forbearance. Or C is for the new one that we are seeing. The creation, modification, or destruction of a legal relation. If you tell me that if you go and create a legal relationship with Tallow Oil Company, if you go ahead and enter into a contract with them to buy your oil from them, I'll make sure that I pay you or I give you a tractor that you shall do the oil business with. And I ask you, are you sure? Are you saying if I go ahead and I sign the contract with Tallow, you will give me a tractor? You said yes, you give me a tractor. I go ahead and I go and create a legal relationship with Tallow, on understanding that you are going to pay me 1,000, 1 million, you're going to give me the tractor like you promised. If I go and I go and sign the agreement with Tallow, and you refuse to pay me, give me the tractor, I can sue you for breach of contract. If you ask me what have I given in return, I will tell you that the creation of the legal relationship I'm going to create based on your promise, that creation of the legal relationship is my consideration, so you must pay me. You told me that if I can go and take admission at Lincoln University, you will pay me $1 million for me to attend the school. I tell you, if I go and take the admission, are you sure you pay me? I go and take the admission, then you refuse to pay. Your promise, you promised me to go and take the admission, and based on your promise, I am going to create a legal relationship. So the creation of the legal relationship shall amount to the consideration in this particular case. Or the modification of a legal relationship. If I end up modifying the legal relationship by, let's say, I have a contract with somebody, you tell me to modify it, so that if you modify it, you pay me an amount of money, or destroy it, terminate your agreement you have with Anglo Gold Ashanti. If you terminate it, I'll pay you $1 million. After I've terminated it, you say you won't pay me. I'll tell you that the destruction of the legal relationship amounts to the consideration. So I can use that one as a basis to now sue you to enforce the promise you made to me. So you've seen 3 meanings so far, according to Section 75 of the American Restatement of Contracts, second edition. You've seen 3 meanings so far, that consideration can be an act other than a promise, that it can also be a forbearance, it can also be the creation, modification, or destruction of a legal relation, or it can also be a returned promise, bargained for, and given in exchange for the promise. I've explained that one already. Return promise. You say you are shipping gold from America to Ghana to me, and I say as soon as you ship it, I'll pay you $1 million. Over here, you haven't shipped it. You only promised me that you ship the gold. I also promised you that when you bring it, I'll pay you $1 million. So I've given you a return promise. That return promise in law is a valid form of consideration. So you've seen that this definition of consideration, according to Section 75 of the American Restatement of Contracts, second edition, is very expansive as compared to what we have seen in Currie and Misa, as we've seen in Dunlop Pneumatic Tire Company Limited versus Selfridge, as we've seen in Thomas and Thomas. So if you have to give a very good definition of consideration and you want to show scholarship, you can transition from Currie and Misa, move on to Dunlop Pneumatic Tire Company Limited versus Selfridge, and you can also move on to Section 75 of the American Restatement of Contracts, second edition, where we define consideration to be an act other than a promise, a forbearance, the creation, modification, or destruction of a legal relation, or a return promise bargained for and given in exchange for the promise. Now, what are the different kinds of consideration we have in law? Consideration can either be executory consideration, it can be an executed consideration, or it can be a past consideration. I'll begin by explaining past consideration. I'll begin by explaining past consideration. So past consideration, if I have already painted your house for you because I'm an artist, and I painted your house for you at my own expense, you are not the one to me to go and do it. And after I painted the house for you, you promised to pay me 1,000 cedis. Remember, I went to paint the house on my own accord. You didn't make any promise to me that you are going to pay me any amount of money. I just went to paint the house. And after I painted the house, then you made the promise. Now, since I have already made a promise, since I have already painted the house, before you ended up making the promise, since I have already painted the house, before you made a promise, it means that my act of painting the vehicle it has already been done before you ended up making the promise. It means that my act that would amount to the consideration, that act has wholly been performed before you ended up making the promise. So in that case, the act amounting to the consideration, it has wholly been performed before you made the promise to me. So that act will amount to a past consideration. So past consideration is when the act amounted to the consideration, it has wholly been performed before the promise is made. That's what we call past consideration. So for example, you tell me I on my own accord, I came to polish your shoe for you because I want to just polish the shoe for you. Then after I finish polishing the shoe, you say that, oh, the way the shoe has been polished is very nice. So you will pay me 1,000 cedis for it. Now, since the polishing has already been done before the promise was made, it means that my act of polishing, this is the consideration, it has already been done before you made the promise. So my act will amount to a past consideration. Then we have executory consideration. For executory consideration, nobody has performed any act. We have only exchanged promises to perform something in future. So for example, the example I gave, you promised to ship gold from America to Ghana for me. And I promise that if you ship the gold to Ghana, I'll pay you $1 million immediately. Now, we exchange these promises on 1st of December. But the gold is supposed to be shipped by 20th December. And it's only when you ship it that I'll have to pay the money. Therefore, as at 1st December, we have a valid contract. Nobody has performed any responsibility or obligation yet, but we have exchanged promises. And since we have exchanged promises, that will amount to a valid consideration. The exchange of promises to be performed in the future are what will amount to the valid consideration. So past consideration is when the act amounted to the consideration has wholly been done or suffered before the promise is made. And executory is when we are exchanging promises to be performed in the future. And then we also have executed consideration. When we say executed consideration, what do we mean? Executed consideration refers to when an act is performed in exchange for a promise, like we have and we saw in the case of Carlyle and Carbolic smoke ball. In Carlyle and Carbolic smoke ball, the promise was made to the whole world: whoever shall buy the medical preparation and use it according to the instructions will pay you £100. Now, what was the consideration that the plaintiff rendered? He executed the act. He went ahead to buy the medical preparation. So it was an act he performed in exchange for the promise that amounts to an executed consideration. So executed consideration is when nobody has performed anything yet, but they have only exchanged promises to perform the acts in future. I tell you that, are you the one that is having this Range Rover? Drive the Range Rover to Tamale. If you come, I'll pay you 1,000 cedis. Over there, nobody has paid anybody any amount of money, but we have exchanged promises to perform it in future. I said, okay, I'll bring the car. You said, if you bring it, I'll pay you. We have exchanged promises to be performed in the future. It becomes an executory consideration. But past consideration is when the act has already been done before the promise is made. And for executed, we are referring to when an act is performed in exchange for a promise, like we usually see in unilateral contracts. So these are the three kinds of consideration you can have: executory, executed, or past consideration. Now that we know the definition of a consideration, We know the different kinds of consideration you can have. There's one critical principle in consideration and contract law that I must make you understand. It is a concept which we usually refer to as consideration need not be adequate, but it must be sufficient. Consideration need not be adequate, but it must be sufficient. What does this mean? It means that you may have a house in a prime area in society worth $5 million. But if you go and enter into an agreement and you agree to sell that house for $100, a house worth $5 million, you enter into an agreement and you agree to sell this for $100. Do not think that you can go to court one day and go and tell the court that, court, please, this house is worth $5 million, but an agreement I entered into, it has made the contract worth only, I signed it for just $100, and therefore it is a bad agreement. Please, the court will not grant you audience. Will not listen to you when you go and say that, because the business as to the value of the consideration, it's for the parties to decide on at the time that they are entering into the contract. So if you go and enter into a contract and you agree on $100 for a house worth $5 million, do not think the court will later interfere with it, because the adequacy of consideration is for the parties to decide at the time of contracting. You, the parties, you are the ones that must agree on how much is supposed to be given as consideration. That will not be a business for the court to decide for you. All the court will be concerned about is that what you have given up as consideration, is it something of value that the law recognizes to be a valid form of consideration? If it's something of value that the law already recognizes to be a valid form of consideration, case closed. That will be a valid form of consideration. So it may be your Range Rover. You may enter into an agreement to sell it to somebody for 5 Ghana cedis, even less than $1. Please, the court will enforce that agreement, because consideration need not be adequate, but it must be sufficient. When we say it must be sufficient, what we mean is that it must be something that the law recognizes to be a valid form of consideration. So long as it's something of value that the law would recognize to be a valid form of consideration, that is the end. Consideration need not be adequate, but it must be sufficient. And you will get this from the case of Bolton and Madden. Bolton is spelled B-O-L-T-O-N. B-O-L-T-O-N. Versus Madden. M-A-D-D-E-N. Bolton and Madden. B-O-L-T-O-N versus Madden. M-A-D-D-E-N. Reported in 1873. And seen in Queen's Bench at page 55. This is what was said by the court, and I quote: the adequacy of consideration is for the parties to decide. The adequacy for consideration is for the parties to consider at the time of contracting. Let me take it again. Bolton and Madden, and I quote: the adequacy of consideration is for the parties to consider at the time of making the contract, and not for the court to consider when it is sought to be enforced. End of quote. The adequacy of consideration is for the parties to consider at the time of making the contract, and not for the court to consider when it is sought to be enforced. What does this mean? It means that when you are talking about the value of what you have given out as consideration, the value is for you, the parties, to consider at the time you are entering into the contract, and not for the court to consider when you are seeking to enforce it. The court will not interfere. The court will say that, oh, but the house at East Legon is supposed to be $5 million. So how can you have agreed to sell it for 10 cedis? Please, the adequacy is for the parties So once the parties have agreed that the house is going for 10 cedis, the court will not interfere with that. Bolton and Madden, consideration need not be adequate, but it must be sufficient. The adequacy of consideration is for the parties to consider at the time of making the contract, and not for the court to consider at the time when the agreement is sought to be enforced. Another case we can look at on the same principle, the case of Chappell and Company Limited versus Nestle. Chappell and Company Limited versus Nestle. Chappell and Company Limited. Chappell and Company Limited versus Nestle Company Limited, reported in 1960 appeals cases at page 87. Now, these are the brief facts of the case. And this case also explains that consideration need not be adequate, but it must be sufficient. And I quote, I'm reading these facts from the case, from Chappell's case book on contract law. The plaintiff owned the copyright in a piece of music titled Rocking Shoes. The defendants, Nestle, arranged for copies of this tune to be manufactured into records. And they offered these records to the public at a stated price, plus 3 rappers from their 6D chocolate bars. Section 8 of the Copyright Act of 1956 permitted the making of records for retail sale, provided that a royalty of 61/4% on the ordinary retail selling price was paid to the plaintiffs. Plaintiffs were informed of the ordinary resale price and they sued, seeking to obtain an injunction claiming a breach of copyright. What I want you to take note over here is that the defendants arranged for copies of this tune to be manufactured into records. And when they offered these records to the public, it was for an amount of money plus 3 rappers. Now, see what the court held. That the rappers were part of the consideration for the sale of the records, although they were of trivial economic value and were thrown away by Nestle. The rappers were part of the consideration for the sale of the records. The rappers were part of the consideration. The rappers were part of the consideration for the sale of the records, although they were of trivial economic value and were thrown away by Nestle. Now, the important point to note about this case is that we are talking about rappers that were practically of no value to Nestle. They were of trivial economic value, but the court is still holding that they will still be deemed to be a part of the consideration. So that the fact that the thing is of no value, it is of trivial economic value, is of no consequence. Because as we have seen, consideration need not be adequate, but it must be sufficient. Listen to the words of the learned justice, Lord Somerville, in this case of Chappell and Company Limited versus Nestle Company Limited. This is what the learned justice says, and I quote. The question then is whether the 3 rappers were part of the consideration. I think they are a part of the consideration. They are so described in the offer. It is said that when received, the wrappers are of no value to Nestle's. This I would have thought irrelevant. A contracting party can stipulate for what consideration he chooses. A peppercorn does not cease to be good consideration if it is established that the promisee does not like the pepper and will throw away the corn. End of quote. What are we getting over here? That as we have been told that a contracting party can stipulate what consideration he chooses. So if you have chosen a particular consideration, then case closed. If you have chosen 100 cedis for your house worth $1 million, case closed. Because as we are told, a peppercorn does not cease to be good consideration if it's established that the promisee does not like pepper and will throw away the corn. If the whole peppercorn it is irrelevant to you, we are told that it will still be deemed to be good consideration. That's why we're told that the wrappers were part of the consideration, even though they were of trivial economic value. So this explains this whole concept to us, that consideration need not be adequate, but it must be what? Sufficient. The court will not be the ones to decide for you what should be the value of your consideration. So long as it qualifies in law to be a valid form of consideration, that is the end. Chappell and Company Limited versus Nestle Company Limited. The next thing to look at is past consideration. Past consideration. And I've explained that to you already. That if I have already performed the act to you, and you now make the promise, so I've already polished your shoe for you without any agreement, and then you now promise to pay me 1,000 cedis. My act of polishing the shoe becomes past consideration because it was wholly done before the promise was made. Now, the common law is that past consideration is not good consideration. That will be sufficient to support the enforcement of the contract. In other words, under the common law, when you render past consideration, we don't regard it as a valid form of consideration. It's not good consideration. So under the common law, if the consideration is past, you cannot rely on that past consideration to enforce the promise. In other words, if you have already polished my shoe for me, and I say, hey, I can see my face in this shoe, so I want to pay you 1,000 cedis for it. If I refuse to pay you the 1,000 cedis, you cannot come and sue me for it because the act of the polishing, it had already been done before I ended up making the promise. So past consideration cannot be deemed to be good consideration under our laws. So under our laws, past consideration cannot be deemed to be good consideration. And then over there, that is the common law. And we can see that in the case of McArdle. McArdle is reported as far back as in the year 1951. McArdle. Now this is what the case of McArdle says. McArdle, this is what the case says. And then I quote. The facts of the case are that a number of children were entitled to inherit a house devised to them by their late father in his will. A number of children were entitled to inherit a house devised to them by their late father in his will. Their mother, the widow, had a life interest in the property, and she was told to hold same in trust for the 5 children. During the lifetime of their mother, one of the children, who was a beneficiary of the estate, lived in the house. In the year 1943, that child's wife carried out some improvements to the property and paid for same. After the wife had completed these improvements, in 1945, the 5 children signed a document addressed to the wife, which read as follows, and I quote, "In consideration of your carrying out certain alterations and improvements to the property, we, the beneficiaries, under the will of the testator, hereby agree that the executors shall repay to you from the said estate, when so distributed, the sum of £488 in settlement of the amount spent on the improvements. End of quote. After the death of the testator's widow, the child's wife sued to claim the amounts. Now let me break down the facts to you. A number of children are entitled to inherit a house that has been devised for them by their late father. Now, one of the children went to live in the house, and that child's wife carried out some improvements while the person was living in the building. And these improvements were done in the year 1943. Now, in 1945, that was when those 5 children who are entitled to inherit the house, they signed a document saying that, oh, you have done all these improvements. In fact, the day we decide to distribute this, we shall distribute the estate. We shall pay you £488 for all the improvements you've carried out. So you see that the act of the wife had already been done. The act of the improvement had already been done before the promise was made to pay the £488. Now, after the death of the testator's widow, the child's wife sued to claim the amounts. It was held that the work had been completed before the promise was made in 1945. The consideration, therefore, was past consideration and will not qualify in law to be a valid form of consideration. So the wife cannot sue to enforce the promise. Even though the 5 people were the ones who said it from their own mouth, that they promised that they shall pay you, that promise, we are told, was not valid, because the promise was made in exchange for something which was a past consideration. If it was past, you have done the act already. When you're doing the act, you didn't have in mind that I'll pay you for it. So why are you complaining now? So the court held that the work had already been done before the promise was made. And so since it was a past consideration, it will not qualify to be good consideration. So it means that on the authority of this case of McArdle, if you have lived in your family house and then you have done some improvements, nobody has sent you done your improvement, then after 5 years, the family says that because of all that you have done, we shall pay you 50,000 cedis. Even if they sign a document, it is bad consideration, because as we have been told in law, bad consideration, past consideration, shall not suffice as a valid form of consideration. Just like we said in McArdle, the wife had carried out all the improvements in the year 1943. And the promise was made in 1945 that he shall pay the wife. The court held that it is past consideration. The act of the improvement was past consideration, and so it will not be deemed to be a valid form of consideration. So the common law is that past consideration will not amount to be a valid form of consideration in order to support the enforcement of a contract. So at common law, past consideration is not good consideration, and the authority for that will be McArdle. McArdle is spelled McArdle, McArdle. So the common law is that past consideration will not be deemed to be good consideration. But there are some exceptions to this rule. There are some exceptions. One exception is when the act in question has been specifically requested by the promissor. And over there, we'll look at the case of Lampleigh versus Brathwait. Another exception is when the act is done by way of business. And over there, we'll look at cases patent, Stewart and Casey. So we shall deal with these exceptions one after the other. Now, exception 1, acts specifically requested by the promissor. Now, what this exception means is that, let's say I'm in the house and then you come and tell me to help you spray your vehicle. Now, when you told me to help you spray your vehicle, we did not discuss any form of consideration. I'm not even a sprayer. Yes, I'm a carpenter, but you told me that I should come and help you to spray your vehicle. Now, after I helped you spray the vehicle, you were like, hey, gentleman, I didn't know you were such a good sprayer. In fact, this one, a professional payer would have charged me 10,000 cedis. But you know what? I think I want to pay you 5,000 cedis for how much you have helped me. Now remember that the spraying had already been done before the promise was made. The spraying of the vehicle had already been done before you promised to pay me the amount of money. We are being told in law that even though the consideration over here is past, even though the consideration of spraying the vehicle over here is past, because you were the one who specifically requested me to come and do the spraying, this promise will be enforceable. I can sue you to claim the 5,000 cedis you promised me, because even though my act of spraying the vehicle is a past consideration, that act was done at the specific request of the promisor. And so even though it is past consideration, it will still be deemed to be good consideration that will support the enforcement of the promise you made to me. So I can sue you to claim the amount of 5,000 cedis you promised. Let me demonstrate this with the case of Lampleigh and Brathwait, reported in the year 1615. I want to take you through these facts very well so that I can explain to you how we are looking at the exception to the common law rule. Remember, the common law rule is that past consideration is not good consideration. We are looking at the first exception of acts specifically requested by the promisor. And the authority for that is Lampleigh versus Brathwait, reported in 1615. Now, these are the facts. The defendant who had killed a man had been convicted of murder and sentenced to death. The convict, that is the defendant, requested the plaintiff to write to Newark to obtain a pardon from King James I. The plaintiff, in compliance with the defendant's request, at his own expense, journeyed to and from London and was eventually able to obtain the pardon from the king. As a result, the defendant was released from prison because his friend had managed to obtain the pardon from the king. Remember, the defendant in this case had killed a man and had been convicted of murder. Then you, the convict, that is the defendant, you requested the plaintiff to do whatever he can do to obtain a pardon from you. This plaintiff wrote to Newark and was able to obtain a pardon from the king. Now, he did all of that at his own expense. When he was able to get a pardon, the defendant was released. After the release, the defendant was so happy that he promised to pay the plaintiff £100 for his trouble. Remember, this case is the year 1615. 1615, the defendant promised to pay plaintiff £100 for his trouble. But later on, the defendant refused to pay. And as a result, the plaintiff sued. Now take a critical look at the facts. At the time the plaintiff was riding all the way to Newark to obtain the pardon, there had been no promise to pay him any amount of money. The promise came after he had performed the act. In other words, the act of riding and going all the way to Newark to obtain the pardon, that act will be a past consideration because that act was performed before the promise was made. So you realize that the promise in this case came subsequent to the performance of the act. The promise to pay the £100 came subsequent to the performance of the act. So the act of going to obtain the pardon was a past consideration. But you see, in this case, this act was done at the specific request of the promisor. The defendant was the one who told him to do it. So as we have seen, if the act was specifically requested by the promisor, even though it's a past consideration, it will nonetheless be enforceable. So it was held that even though the consideration was past, the claimant could enforce the promise to pay him £1,000 because the act had already been done. Because the act amounting to the past consideration was specifically done at the express request of the promisor. It was done at the express request of the promisor. So that is the case of Lampleigh and Brathwait, and it is an exception to the common law rule on past consideration. Because under the common law, past consideration will not suffice as good consideration. And as you have seen in Lampleigh and Brathwait, when the act amounting to the past consideration is done at the express request of the promisor, it shall nonetheless suffice as a valid form of consideration. Another case that relates to this exception is a case of Pao On versus Lau Yu Long. Pao is spelled P-A-O, On is O-N, Pao On versus Lau, L-A-U, U-Y-I-U, Long, L-O-N-G. So P-A-O and then a space, O-N versus L-A-U, a space, Y-I-U, a space, L-O-N-D. This is what Lord Scarman said, and I quote, "An act done before the giving of a promise to make a payment or to confer some other benefit can sometimes be consideration for the promise. The act must have been done at the promisor's request. The parties must have understood that the act was to be remunerated either in payment or the conferment of some other benefits. And payment or the conferment of a benefit must be legally enforceable had it been promised in advance." So that is the exception, that when the act is done at the express request of the promisor, even though it may be past consideration, it may nonetheless be valid consideration, which will support the enforcement of a promise. The next case we shall look at, the next exception, are acts done by way of business. Acts done by way of business. What it means is that if I'm here and I'm a lawyer, and you know my ordinary work as a lawyer requires me to draft conveyances on business terms for people. And then you come to me and you ask me to draft a conveyance, knowing very well that by nature of the business, you will definitely pay for it. Now, when I render the service to you, and you subsequently agree to pay me $5,000 for the service I've rendered, remember that at the time that I rendered the service, there may have been no consideration. That was agreed. But in this case, you have subsequently agreed to pay me an amount of money. But it's an act done by way of business. It's an act done by way of business. Now we are being told that even though the consideration was passed, you may nonetheless be liable to pay me an amount of money for it. That is what we call acts done by way of business. Acts done by way of business. Acts done by way of business. So let us look at the fact of this in re cases patent Stewart versus Casey, reported in 1982, 1 Chancery Division at page 104. Now, the facts given in this case are going to demonstrate that if an act is done by way of business, and after the act has been done, there's a promise made by one party that he's going to pay the other person. For example, you go to the mechanic shop. You know it's the ordinary work of the mechanic to repair vehicles. But when you get there, there was no discussion of any monetary consideration. But you go there, and then you go ahead and you render the service. Now, the mechanic fixed the vehicle for you, and you agree that you shall pay the mechanic 5,000 cedis for the service he has rendered. Now, because you are aware that the mechanic's ordinary business is to repair vehicles, now, after you agreed to pay him the amount, after he has rendered the service for you, you shall be required to pay him the amount of money. Now, these are the facts of this case of in re cases patent Stewart versus Casey, reported in 1892. Now, the facts in this case that I'm going to give out, I was able to get these facts from Law of Contracts in Ghana, the book titled Law of Contracts in Ghana, written by Christian Dona Hammond. Law of Contracts in Ghana, written by Christian Dona Hammond. That's where I got these facts from. And this is what the case says. A and B, joint owners of certain patent rights, wrote to C stating that in consideration of your services as the practical manager in working our patents, we hereby agree to give you 1/3 share of the patents. A and B subsequently refused to fulfill this promise, arguing that the promise was made only in return for C's past services as manager, and therefore there was no consideration to support it. It was held by Bowen LG as follows. Now, even if it were true, as some specific students of law believe, that a past service cannot support a future promise, you must look at the document to see if the promise cannot receive a proper effect in some other way. Now, the fact of a past service raises an implication that at the time it was rendered, it was to be paid for. When you get, it was to be paid for, and if it was a service which was to be paid for, when you get in the subsequent document a promise to pay, that promise may be treated as either an admission which evidences as a positive bargain which fixes the amount that's reasonable remuneration of the faith of which the service was originally rendered. So that here, for past services, there's an ample justification for the promise to give the third share. Now, when you take a critical look at this case of Henry Casey's patent, Stewart and Casey, you realize that the service was rendered before the promise was made. But the judge is saying that that service that was rendered, it was a service that was rendered by way of business. So when you subsequently come and promise that you shall pay an amount of money, it is more like an admission that you are aware that you are supposed to pay. So you are now agreeing to pay. So you'll be bound by that particular promise. So that is another exception to the past consideration rule. That even though consideration may be past, it may be good consideration if that past consideration was done by way of business. So the common law rule, as we have seen, is that past consideration will not be deemed to be good consideration. And this common law position has been affirmed by the case of Henry McArdle. But we have seen the exceptions. One is when the act amounting to the past consideration was specifically requested by the promissor, or when the act was done by way of business. The next concept you are supposed to explain under consideration is forbearance as consideration. You remember when we were discussing the definition of consideration, we mentioned that consideration can also be an act of forbearance. I want you to know that there's case law to support the view that forbearing to do something that you are lawfully entitled to do can suffice as good consideration. That forbearance can amount to good consideration in law, and the authority for that is Hammer and Sidway. Hammer and Sidway. Hammer is spelled H-A-M-E-R versus Sidway. Sidway is spelled S-I-D-W-A-Y. Hammer versus Sidway. Hammer versus Sidway. Now, these are the brief facts of Hammer versus Sidway as we can glean from Chappell's casebook on contract law. These are the facts. An uncle promised his nephew $5,000 if the nephew would refrain from drinking liquor, using tobacco, swearing, and playing cards or billboards for money until he became 21 years of age. An uncle promised his nephew $5,000 if he would refrain from drinking liquor, using tobacco, swearing, and playing cards or billiards for money until he should become 21 years of age. The nephew complied and refrained from drinking liquor. He refrained from using tobacco. He refrained from swearing. He refrained from playing cards. He refrained from doing all of that. But the uncle's executor refused to make the payment. So the nephew sued that you are the one who told me that if I should refrain from doing this, you pay me. I've refrained. The uncle's executor is refusing to make payments. The court held that the promise was enforceable because the nephew had provided consideration for the uncle's promise by restricting his lawful freedom of action. The court noted that the nephew had a lawful right to swear lawful right to play cards, and he refrained from doing all this, the act of refraining and forbearing to do those things shall amount to a valid form of consideration. Valid form of consideration. So all we have done so far is that we have said that consideration need not be adequate, but it must be sufficient. Consideration need not be adequate, but it must be sufficient. And to determine the sufficiency of consideration, what we look out for is to find out whether whatever we are looking at in law amounts to a valid form of consideration. Is this something of value that the law is recognizing to be a valid form of consideration? So in this lecture, we have defined consideration from Currie and Misa. We have also looked at Thomas and Thomas, and we've looked at the restatement on the law of contracts. We've also gone ahead to look at the different kinds of consideration, where we look at executory consideration, executed consideration, and then past consideration. We have proceeded to look at what amounts to what the concept means by saying that consideration need not be adequate, but it must be sufficient. We've gone through the cases. We've looked at how we can explain what we mean by saying that past consideration and how it's not the good consideration. And then we look at exceptions to the past consideration rule. Now, in our next lecture, remember we mentioned that sufficiency of consideration means that what would the law recognize as a valid form of consideration? Now, under the common law, there are some conduct which do not amount to sufficient consideration. Examples are promise to perform pre-existing legal obligations and part payment of debts. Now, these common law rules have been modified by the Ghana Contract Act of 1960, Act 25. So in our next lecture, we shall discuss the modifications introduced by Ghana's Contract Act of 1960, Act 25, into the common law rules of consideration. So this is where we shall draw the curtains on this lecture of consideration. In our next lecture, we shall look at the reforms that have been introduced by the common law rules on consideration. This is where we shall draw the curtains on this lecture. Thank you.